I'm trying to get it back to somebody who can make a claim that it's property, and without that property being returned, they're going to accrue financial loss. Or be
I understand. That is fairly simple. But, also what I was looking at is, the court lacked subject matter jurisdiction to begin with because, number one, on these type of charges, they should, and if you watch the paper, you will see that they do, in fact, whenever they charge a licensed agent, doctor, dentist, pharmacist, or veterinarian with these types of charges, the first thing they do is they run them through administrative hearings. Right. Because at the administrative hearings, the first thing they produce is the license that subjects them to that act.
Right.
Of course, these people don't have the license, so they never take you through the administrative side. Then, because they're not exhausting the administrative side, and there is no real party of interest to sign the complaint or the affidavit to support the complaint, because how can an administrative agency of government, the COP, be a real party of interest to sign the complaint to get the grand jury investigation if, in fact, they had a grand jury investigation? In fact, what's funny about his case is the affidavit to support the complaint is not in the docket, and neither is the affidavits or the arrest warrants.
Let's start with the license. The license is a fun one. Is there a way that the United States, or is the United States who charged him, was it a federal thing he went under?
It was a state of Arkansas.
Great, a state. Is there somewhere in the state where a schedule, that's probably like a Schedule A drug, whatever they call it, is there somewhere in the state that if you had a license, you could distribute something like that?
Well, that's funny. What the states have done, they've adopted the Uniform Substance Control Act, I believe is what it's called. And within that act, they actually have made a provision that it does not apply to the ultimate users.
I'm saying, just for laughs, just amuse me, because I know the feds do. Do you believe that the state might have a provision in there that if you are a licensed physician or a licensed chemist or a licensed radiologist, for some reason, if you have to have this, in your possession or whatever, that you would be permitted if you had the proper license?
I don't know about the cultivation laws. They were pretty strict on those, so, I can't answer that one.
Okay, well, I'm just throwing this out for laughs. It could be we could be widgets we're talking about. It doesn't have to be cannabis. It can just be widgets. And what I'm saying is, could they license something that's unlawful?
Well, that's what they're doing, yes.
What I'm saying is, well, then, if it's licensable, if that's even such a word, well, then it must be lawful as well. So that's why I use the common law all the time. So if a doctor can prescribe it, or a doctor can cultivate it, or a doctor can grow it, or a chemist can manufacture it, if he's had the proper license to do it, then it must be lawful, because the state can't license something that's not lawful. So at one time, it has to be lawful, because they can't license an unlawful act, can they?
Right. I think that's the whole problem there, is that what they've done is they've outlawed the licensing people from being the ones that can cultivate that. That's the whole problem.
You know and I know law is simple. As long as there's no direct harm or loss to a man who can stand in court and make the claim, that is law.
Right. Well, see, this is why I believe that's why they don't bother to attempt to exhaust the administrative remedies, because they cannot bring you in there at the administrative level. So
all I'm trying to say is that if it's lawful, if it's licensable, it's lawful. And the law is simple. As long as he caused no harm or injury and no man has come forward to say that he breached the peace with that man, or that there's or he had a contract saying that he wouldn't do such an act, and now the man has suffered, the other man has accrued a loss or harm, or his property has been damaged, they have no case. So if it could be licensed, it has to be lawful. You can't license an unlawful activity. It can't be done.
Well, on top of that, the legislature never created an act that says the people or the man can't grow this plant.
Whether they did or not, all I'm trying to say is, law is simple. And like I said, I'm not going to repeat it because you know it really well as well. And what I'm trying to do is, because like I said, you seem kind of young, so I believed exactly what you believe. I was so vehement in the belief of codes and acts, and you have no idea. About 2-3 years ago, I was like, oh my God, what a waste of time. Law is so simple. What am I doing? If it can be licensed, it's lawful. And the law is, did I hurt anybody when I was doing it? No. then you have no status. You have no standing to bring a complaint before me. I'm going to move a claim now against you as the prosecutor. Are you sure you still want to prosecute me? So that's the whole problem with everybody. They're coming into court as a defendant under a complaint by an act or by a regulation or by a rule or by an ordinance or by a statute. When at all times they always had the law on their side. Did I hurt anybody? No. Well, then I just threw the trump card down on the table and say, hey, that's no fair. We took years developing this chess game against you. It's like, you know what? Laura's checkers. We're going back to checkers. And guess what? You got a chess game going against me. You know what? I like to play chess sometimes. It's fun. But you know what? I think I'm going to lose. So you know what? I'm just going to go over to checkers. And I'm done. 1, 2, 3. I'm done. You going to move? No. Okay. See ya. But it's fun to do what you're doing. I did the same thing for years, played all this acts and legislating, appeal. I wrote briefs. I was wonderful. What a waste of time. Never again. Now everything's simple. But like I said, thank God, man, you're learning. You're doing exactly what I did. I got a mountain of books. I'm going to put it on my website so you can take a look at what I look like. Because when you see what I look like, you're going to be like, oh, my God, this guy looks like a biker. Oh, my God, this guy lives on a mountain. Oh, my God, this guy's got like cattle and, chickens and cats. He's just a Joe Normal. He's not no Yale, Harvard school, graduate. So I say to people, if you see what I look like and you think that I'm a pretty sharp guy, well, you probably say, well, hell, I'm smart. I look smart than that guy. Well, hell, I should be able to figure this out if he can. It sounds pretty simple what he's doing. That's the whole trick. I just went down to being totally simple. I'm tired of wrangling with these attorneys because they're doublespeak and their language is designed to, and like I said, if you ever heard Dean Clifford explain that, he was walking through the hallway one time in court with some lawyer lady, and he had a Black's Law Dictionary. And she said, give me that book. There's no need for you to read that. You're only going to hurt yourself with it. And she was right. Because when you're trying to speak their language, they have such a way to manipulate simple, basic English common words that when you try to master it, as far as they're concerned, you're not a card-carrying Teamster union member. So they're not going to recognize you speaking in their court to begin with. You're not a union member. You're not going to lay a brick. You're not going to drive a truck through this courthouse. You need a Teamster card. You need a union card. You need a bar card. You ain't got one. So we're not going to recognize you. So anything that's coming out of your mouth, we're going to take it as common language from like the pigs, from the people. We don't believe that you have the right to even speak in our courts. So thank God we have a common law court in this concept in this country where the common man can speak. And then we, under that Trinzi versus Pagliaro, block out the lawyers. And they have no right to move a court or motion a court or motion for summary judgment. They have no right to move a court in common law. And thank God this is not France, because everything I say to you folks would be totally a waste of time, because the code and statute is the superior law, and everybody in that country agrees that we're going to move this way. If the police accuse you of murdering your roommate like Amanda Fox, she has to prove she wasn't in the house. She has to prove she didn't kill it. She has to prove she didn't have no motivation to do it. And she has to prove that there's witnesses to prove that she was not the one killing her roommate. And her family said this is totally upside down from America, where you're presumed innocent until guilty. But under administrative law, like your friend's going through, he has to prove that he's innocent. It's backwards. It's operating like France. Administrative law in this country is like you have to prove you weren't doing 55 miles an hour. This is acting like European code, like Napoleonic code. So when you're moving under code, you have to prove that you're innocent. And it sounds totally backwards to the American concept of, wait a second, you have to prove that by me doing what I did, there's an injured person, or an injured party, or an injured man. Bring it. Oh, no, you just violated this code and we're going to throw the book at you. It's like, no, this ain't France. This ain't France. Back it up. I'm going to take it over to the common law side. And that pisses them off. And everybody tries to say, there's no such thing as common law. I said, well, go to www.uscourts.gov, page 4, about 3/4 way down on the right. Angeles did that on her show one night. She's like, oh, my God, Carl says right there, all state courts are common law courts. So,
I did that also, right, when you first brought that up, and, and looked at those photos they have on there that they show the tables facing the jury and the judge is up there on the left.
Yeah, and nobody understands this is how this really works. It's truly a tribunal.
So now this lady from Canada, once she does her writ of habeas corpus and it's ignored, what's the next step? You got to do writ of error on whatever the judge is. If the judge goes and brings a ruling or an order.
What she's going to do is she's going to make an order for the return of property. It's simple. And she's going to compare it with writ of habeas corpus, see Exhibit A, and it's going to be attached to the order. And if the judge has no capacity to deny her order, all he can do is look at the other side and say, what say whoever decides to show up on the other side? And they're going to have nothing to say, because then she could use the old, does he have any first-hand, she's going to say, I object, Your Honor, and he's going to say, object to what? Is that a man or woman with any first-hand knowledge or to any capacity to make a claim for that property to be lawfully placed into their possession? And they're going to say, well, under the Canadian code, no, that's a code. I said a lawful claim. I didn't say any Canadian code, by law, by any lawful authority, because this is a common law nation. Because, like I said, she said that she was, that they ignored her for the first couple of months, and she was showing me all this paperwork, beautiful paperwork, written in both English and French. It was beautiful. But I said, my God, lady, they're going to laugh at you. And she said, yeah, well, they've been told to ignore us until we handed them this thing, on Wednesday, and my God, the judge came down and they started talking to us about what we're filing and why. And I said, all you're supposed to do is say, we'll take that into advisement. You never say to the judge, okay, we'll change it. Because then the judge will say, oh, good, these people really don't believe what they believe in. Because when they write something and it's a claim, it's etched in stone, written in stone, you add no word, you take none. And that's an old Bible saying, add no word, take none. And it's written in stone, like the Ten Commandments are written in stone. You can't modify it. It's like, well, the guy said, well, Moses, how about we modify that a little bit? How about that number 6 count's kind of strict? How about it's not that thou shalt not kill. How about we say thou shalt not murder? Because sometimes we have to kill. No, it's like, look, I'm not getting into semantics with you. This is my claim. This is the order. This is how it stands. Is anybody going to make against this order, against this commandment? This is what I command. This is what I order. Is there anybody here who believes they have a right to modify my order or have a right to make a claim adjustment here? I'd love to see that. Maybe another woman whose DNA matches mine, but other than that, that's going to be pretty hard to prove that some person has a superior or an equal claim, or any claim, or any vested interest in that property. And like you said, the judge, winches when they say property, because they hate that. Because the judge knows he has no control over property. If you say it's private property, there's nothing to do about it. Once it's been established that it's your property, they no longer have any jurisdiction or control over it for all time. It's done. So, yeah, it should be interesting. Like we want to work with the lady a little bit, and she's still on the phone. Right, Jessica?
Yes, I'm still here.
We think she might pull it off.
We're hoping. I guess we're just kind of sitting now, just to clarify, we want to make sure that we nullify or supersede what the judge has changed on our claim. So how do we go about doing that? Do we write a letter to file with it that, basically says, no, we don't believe that we need to use the word children because it diminishes their capacity, or that, I'm not too sure how to proceed with that one. I just need some clarity.
When you placed a claim before the court, I guess I'm going to have to see what you did. But did you write it as a habeas corpus, or did you just do return of property?
The original one, the one that the judge put his stamp and everything on, but changed our word property to children, that was the habeas corpus motion.
Okay, yeah, because see, that's dangerous. Oh, you understand what motion means now, right, compared to order?
Right. So
yeah,
now that's how our case has been opened up, is with this motion.
Since nobody has answered to it yet, you have every right to go back and amend your claim until somebody has answered it. And once somebody answers it, then you have to get leave of court, which means all parties have to agree to your amended claim. But until somebody makes an answer to your claim, you could change it as many times as you want until it's answered.
Okay, so we can make all the changes until someone answers. And if someone does answer, we need to apply for leave of court.
And you'll never get it. Right. Once you make your claim, once you said that they're going to say it cost us $10 million to already prepare a case against her, and it'd be, and for us to our position to let her modify, let her just ride with what what I'm doing is saying you're playing poker. You said you're all in. Either I'm going to get my kids now or never going to get them.
Right.
No more administrative nonsense, no more hearings, no more nothing. We're going right for the trial. We're all in, and this is it. And they're going to say to you, well, are you sure you got $1 million on the table? You could still go home with $1 million and your kids. Do you really want $2 million and your kids? Why don't you cut a deal with us? And you know what? We'll let you take your bet back off the board, and we'll let you have your kids back, but you got to let us come into your house once a year.
No deals on that, sorry.
Right. Right, but that's what they're going to try to do. They're saying, are you sure? They're going to try to bluff you. And you got to say, do I think I got a good hand? You know you got 4 aces. There's no hand in poker that's going to be 4 aces. But somehow you might freak out and say, I got 4 aces. Do I really got a good hand? Do I really believe in what I'm doing? And that's what the judges did to you the other day. He was testing you to see if you really believe you got 4 aces, because you got 4 aces.
Right.
So he said, well, why do you modify property and make it a child?